and somewhat inland, covering a lot of California counties. The Eastern District sits in Sacramento and Fresno. The Central District is in Los Angeles, and the Southern District is in San Diego. So you've got the federal courts are split up. Some smaller states, smaller population states like Nevada, Rhode Island, Alaska, only have one federal district. What goes on there looks very much like what goes on in the Superior Court and in the United States District Court. Let's try and put some flesh on this thing. Assume that after your arrest and the dismissal of the charges against you when you criticized Mayor Bates, that he sues you for libel, for having falsely accused him of corruption. And somebody comes around, a process server, and serves you with papers, it's summons and complaint, that requires you to respond to the complaint within a certain number of days. And so you have to hire a lawyer to do that. The mayor is suing you for big bucks, a lot of money. You confer with your lawyer and say, wait, I thought I had a right to criticize the mayor, a constitutional right and so on. And the lawyer may say to you in confidence, confidential attorney-client communication, well, that's right as a general matter, but that doesn't mean that libel law can't penalize you for having said something false and defamatory about the mayor. Maybe that you knew was false when you made it. And so you say to the lawyer, well, I'm going to fight this. And so the lawyer files a motion. The mayor has sued you in Superior Court in Alameda County, and your lawyer files a motion to dismiss the case as a matter of law, that you have a constitutional right under the First Amendment to criticize the mayor, even falsely. And you want the case dismissed without any trial at all. And the other side, the mayor's lawyer comes in and says, no, libel law hasn't been abolished, and if it's false and defamatory, meets the other requirements of libel law, then you don't have any First Amendment defense to that. And here the allegation is that she knew that it was false, and she acted maliciously. And so the judge said, well, I can't dismiss this case out of hand. It's going to have to go to trial. And so you go through the agonizing process and expensive process of preparing for trial. The mayor's lawyer takes your deposition, where you're brought into some lawyer's office and under oath, sworn to tell the truth. A court reporter is there, sitting down, taking every word that you say, every question, every answer. A transcript is prepared of the deposition. And then they go through whatever documents they can find that might be interesting. They interview, depose other witnesses under oath and so on. And then finally a date comes up for trial, and you go down to the Superior Court. A jury is impaneled, sworn in, and witnesses are called, documents are introduced in evidence, and at the end of the evidence, the judge says to the jury, okay, here are your instructions about what the law is that applies to this case. You are the judges of the facts. You decide what happened. He said, she said. You decide what happened, and then apply the rules of law that I'm giving you now to those facts. And the jury retires, deliberates, comes back with a verdict against you of $500,000 for defaming the mayor. You write a check? Borrow the money? You pay him? No. What do? You appeal. Yeah. Where do you appeal to? Well, from the Superior Court, you appeal to the California Court of Appeal. And there are several courts of appeal around the state, again, geographically located. We here are in the First District Court of Appeal, headquarters in San Francisco, and covers a whole bunch of counties around, all of the counties around the Bay Area. And I forget how many courts of appeal there are these days, 6, 7, something like that. So you appeal to the Court of Appeal. What happens there is an entirely different scene, almost bloodless, colorless, because there aren't any people there. You go into the Court of Appeal for a hearing, for an argument, and there's three judges, not one, but three, sitting up there. And they used to be all old white men. Now there's some diversity on the bench. There's no jury in the Court of Appeal. They're through. They're finished. The jury was in the Superior Court. They decided. They did their duty. They decided the case. There's no jury. Nobody's going to inquire into what the facts are on the Court of Appeal. The Court of Appeal is deciding whether the judgment rendered in the lower court is going to be affirmed or reversed as a matter of law. And when your case goes to the Court of Appeal, what happens is the record of the case is assembled by the clerk of the Superior Court. And the record of the case is the transcript of all of the testimony taken in court, and all the documentary evidence, and whatever pleadings, complaints, answers, and so on, are part of the record filed in the trial court. And the clerk of the court boxes up those documents. It might be as small as that, or it might be many cartons full of documents, and ships them. The record goes to the Court of Appeal. And when the record hits the Court of Appeal, I'm simplifying a little bit, when the record hits the Court of Appeal, then the Court of Appeal says, all right, now, your brief, you lost in the Superior Court. You're the appellant. You're appealing. Your brief is due, in this case, in 30 days. So your lawyer writes a brief. And a brief is a written argument by the lawyer, which lays out the proceedings in the court below, what happened procedurally. It lays out the facts, both undisputed and as found by the jury, and then makes an argument with separate argument points. And your argument points are, my liability in this case is precluded by the First Amendment to the United States Constitution. As a matter of law, I had the right to say what I said, true or false. Your constitutional argument, and your second argument is, there was insufficient evidence before the jury for them to come out the way they did. That they made a mistake in assessing the facts, and the case should be dismissed for that, should be reversed for that reason. Then Mayor Bates' lawyer files a brief 30 days later, in which, and it looks very much the same. It has what the proceedings below were, what his spin on the facts is, and the arguments that the mayor makes. And then you have a reply brief. And these briefs, as I say somewhere in the reader, are not brief. They're as long as lawyers can get away with. There's a page limit on the number of pages that you can put in a brief. Each court has its own page limit. So after the briefs are all filed, then the court sets a date for oral argument in the case, and you can go with your lawyer to the Court of Appeal over in San Francisco and sit there. There probably won't be anybody else in the courtroom except the lawyers and parties in other cases being argued that day. The three judges file in, they call your case, the lawyer stands up, makes an argument to the court, which is frequently, in all courts, all appellate courts, interrupted by questions, devil's advocate type questions, and factual questions, what did the jury find here, and stuff like that, and questions about the principle of law that you're arguing. Well, how far does this argument go? I mean, doesn't this mean that people can say anything they want to, false, defamatory, maliciously, about any government official? Is that what your argument means? And the lawyer has to cope with the hard questions posed by the various judges. At the conclusion of the argument, lasts an hour, typically, 30 minutes on each side. At the conclusion of the argument, the judges, they may have more than one argument in one sitting, but at the conclusion of that day's sitting, they file out and go back to their conference room and vote on how the case should come out. And in your case, they voted 2-1 in favor of the mayor. Affirm the decision below. Do you write the check? Yeah? Get it over with, right? Come up with a $500K. You appeal. You want to appeal. I'll give you a dotted line to the California Supreme Court. It's a dotted line because the jurisdiction of the California Supreme Court is discretionary. That is, you do not have a right to have the court hear your case. What you file with the Supreme Court when you've lost in the Court of Appeal is a petition for review. And the court receives hundreds of petitions for review every year and doesn't grant very many of them. You have to make the case that the Court of Appeal not simply was wrong, but the issue presented in this case is one that's worthy of being decided by the highest court in the state. That it's an issue of statewide application that affects hundreds, thousands, maybe millions of people, and therefore requires resolution by the California Supreme Court. And I'm sorry to say that in your case, the court reviewed the petition for review and denied it. No, let's have a ray of hope. By a vote of 4-3, with 7 justices on the California Supreme Court, the process that I described in the Court of Appeal is exactly the same in the California Supreme Court. But once the court grants the petition for review, then the briefing process unfolds. The argument process is the same. The justices go back to deliberate. And in your case, they decide 4-3 in your favor. So relax. But Mayor Bates thinks his rights have been infringed by that anomalous, illogical, absurd decision in the Court of Appeal. So what does he do? Yeah, you guessed it. Another dotted line that goes to the U.S. Supreme Court. That sits like astride the Colossus, sitting astride the whole system. Supreme Court's at the very top. And Mayor Bates files a petition for certiorari. Certiorari is a Latin. Certiorari is a Latin term that the meaning of which I've forgotten. What it is a document that looks like a brief, but it's called petition for certiorari. And it's like the petition for review in the California system. You file the petition with the Supreme Court in Washington. It's nicely printed. They have to be printed, even these days. It's a little booklet. And it tells the court what's happened here, factually, procedurally. First thing in the petition for certiorari, you open the page, and the first thing it says is, what's the issue presented here? And so Mayor Bates' lawyer is going to say something like, this case involves the question whether someone may falsely, maliciously, knowing that the statement is false, defame a public official. Or, alternatively, whether the First Amendment protects the individual who engages in that defamation from any liability. And then there will appear in the petition an argument for why the court should take the case. And the argument will be much like in the California system. This is an issue of nationwide importance that affects millions of people and goes to the heart of our civil liberties. From a public official's perspective, our right to be free of maliciously false criticism. On your side, the right to say whatever I want to say about the people who are temporarily in charge of my government. And those issues are important, and the court ought to decide that. And if there are divergent decisions, different courts around the country have come out differently on that issue, that's a good reason for the Supreme Court to get involved. But the odds of getting your case reviewed by the Supreme Court statistically are minuscule. The court receives, I think it's up to about 9,000 petitions for certiorari every year. And the court grants certiorari, that is, agrees to hear the case in about 70 cases. So do the math. Your chances of getting your case heard are extremely slim statistically. Yes, everybody knew that the court would grant certiorari in the medical care reform cases, both because they are of blockbuster importance to our society and because the lower courts split in deciding on this. So those cases are going to the United States Supreme Court. The federal system is much like the state system in that there's an appeal from the district court, and the case has been tried in federal court, to the United States Court of Appeals. And for some weird reason, in the federal system, it's a court of appeals with an S, whereas in the California system, it's Court of Appeal. And There is a Court of Appeals. They're split up geographically. We are, in this part of the world, in the Ninth Circuit Court of Appeals. And the Ninth Circuit is enormous. It's the biggest circuit in the country. It covers all of California, Washington, Oregon, Nevada, Idaho, Montana, Alaska, Hawaii, some islands out in the Pacific, maybe Arizona. I may be missing something. Enormous Court of Appeal geographic jurisdiction. And their headquarters is in San Francisco, a beautiful old building on the corner of 7th and Mission. We'll look at the courtrooms in there someday. Gorgeous marble and carved wood and stuff. And they operate much like I described the process in the Court of Appeal. 3 judges, simply hearing the law, no juries, no facts are found. The record is frozen in the trial court. When everything's over with in the trial court, there won't be any new facts introduced into the case, just arguments. And then you've got, at the top of the whole system, the Supreme Court of the United States, which under the Supremacy Clause of the Constitution, Article 6, I think it is, under the Supremacy Clause, the Constitution and the court's interpretation of it and federal laws are the supreme law of the land and must be complied with by all of the lower courts, including all of the states. So the federal government has taken some power away from the states by empowering the Supreme Court to decide what the law of the land is. The states are free to grant more rights to their citizens than are required by the federal Constitution. For example, the example I use in the reader is that, as we'll talk about later in the course, there is no federal constitutional right under the First Amendment to demand the governor or any state agency to give you records that you can look at, public records. You don't have a federal constitutional right to do that. The First Amendment doesn't empower all of us to demand that the state government produce records that we would be interested in looking at. Well, it doesn't violate the First Amendment for a state to say, we recognize we don't have to, but as a matter of good public policy, we enact a state public records law, which we have in California, which requires state agencies to make available for inspection by citizens records that they want to see. Sure, there are a lot of exemptions to the Public Records Act, but the basic principle is there, is that we citizens have a right to see what our government is up to by looking at the records that the government maintains. Well, it doesn't violate the First Amendment for a state to do that. The Bill of Rights is a floor, not a ceiling. States are free to grant more rights to their citizens than they're required to give them by the floor, by the Bill of Rights, by the Constitution. Is your head spinning about the federal system and how the courts are gone? Can we clear up some confusion before it goes any further? Questions about any of this? Yeah, well, I try not to repeat myself about the floor and the ceiling, but the idea is that the federal Constitution confers in the Bill of Rights. Let's take the Bill of Rights. The First Amendment, Fourth Amendment, Fifth, Sixth, Seventh, Eighth are the principal individual rights parts of the Bill of Rights. As interpreted by the Supreme Court, you, for example, don't have a right to say whatever you want to say, whenever you want to say it, wherever. The First Amendment doesn't provide that. That doesn't mean that the state can't take a different position on that and say, as a matter of state law, you can criticize the mayor. You can do other things that the Bill of Rights doesn't give you the right to. So the Bill of Rights is just the floor. The state can't go below the floor and deny you rights that are required by the Bill of Rights, but the state can give you rights. Take press passes, or maybe a more obvious thing. Reporters don't have the right, just because they're reporters, to go into government buildings and to go participate in various proceedings and so on. Go, in local places, to go to the scene of a fire or demonstration and so on. They could be screened off by police lines and so on. And there wouldn't be any constitutional problem with that, as we'll see later in the course. Reporters don't have any special rights to go places and do things that the rest of us don't have. So as a matter of First Amendment rights, reporters don't have any right to go these places. But in fact, government, in its own interest, issues press passes to reporters, for the newspapers, for television, radio stations, that allow them, they show their press pass to the officer in charge there, that allow them to go behind police lines and snoop around and report stories. That's in all of our interest, that reporters be able to do that, but they're certainly not required to do that. The state's not required to do that by the First Amendment.